Hi everybody, my name is Neil Bhartia. I work with Syndicate Legal and I'm a bankruptcy attorney, and I also specialize in car accidents. We get a ton of questions about bankruptcy every day, and I thought it was time we got a little bit more up close and personal and put together this video blog. That way we can have a lot of the questions answered face to face, if you will, instead of the routine of answering emails over and over. I'm happy to answer any emails, by the way. You can always email us at info@syndicatelegal.com. That's spelled SYNDICATELEGAL.com. And ask us anything you'd like about bankruptcy. We specialize in Chapter 7s and Chapter 13s. Today we're not going to get into the difference between the two so much as we are going to answer a few brief questions about Chapter 7s. And every week we plan to post another blog with more questions. So gradually we should have most of the major questions answered that tend to come up over and over with everybody. So we're based out of Woodland Hills, California. However, we do file bankruptcies all over the Central District of California. What does that cover? That basically covers everywhere from Santa Barbara over to Riverside, up from Silmar, Palmdale, even Lancaster, down to Orange County, California. So we file all over the place, and I believe we're very good at what we do. So without further ado, let's answer some of the common questions we get. And we should get through about 3 or 4 of them today, and we'll get through more on another episode. So, number one question, which I often find rather funny, is when I'm asked, if I file bankruptcy, actually if you file bankruptcy, will you go to jail? The answer is no. I should give the standard answer from an attorney, which is maybe, but in this case, typically not. Bankruptcy is a civil proceeding, although it's hosted by the federal government. It is a civil proceeding nonetheless. You're not going to jail because jail involves a crime. Now, can you ever go to jail because of filing a bankruptcy? Yeah, potentially. So you do know the FBI does investigate bankruptcy crimes. What's a bankruptcy crime? Well, if you lie on your paperwork, you're trying to hide assets, what have you, you're basically lying to the courts about what's going on. You could go to jail for that, just as you could go to jail for lying on any court-related matter, regardless of whether it's a bankruptcy or something else. Basically, you're lying under penalty of perjury. But generally, if you are honest, you're honest with me, your attorney, you're honest with the courts, and you qualify for bankruptcy, there's really no issue of you going to jail. Even if somehow you don't end up qualifying for bankruptcy, you wouldn't go to jail. It's not a criminal proceeding. There are 2 areas of law. There's the criminal side of law, and then there's the civil side of law. This is more the civil side of law. So no, notwithstanding any sort of fraud, you would not go to jail for filing bankruptcy. Question number 2. Do you have to go to court if you file bankruptcy? And the short answer to that is, in a Chapter 7, no. Actually, you don't even have to go to a court proceeding in Chapter 13 either. Chapter 7, you do have to go to a hearing. It's called a 341 hearing, also known as the meeting of creditors. And at that hearing, it's like an administrative hearing, whereas an attorney who's appointed by the Department of Justice, that attorney is referred to as a trustee. That trustee will be analyzing your paperwork and asking you questions about your bankruptcy paperwork so that you could answer those questions on the record. Is this court? No, you'll often hear it referred to as your court date, but it's not really court. You're not in a court of law. There's not a judge there. It's just another attorney who's an attorney like me, a private attorney appointed by the court system or the Department of Justice to analyze your case. So it's an administrative hearing. It's very informal. You're you're being sworn in, but you're not really talking to a judge or what have you. So while it's nerve-wracking for many people because it has the guise of a court proceeding, it's not. You're not in a courthouse. It's a big open room. And on another episode, we'll get into the nuances of what kind of questions they'll ask you. But no, you don't have to go to court. It's an administrative hearing, and it's very informal. That doesn't mean you shouldn't dress up a little bit or be respectful, but it's not court, so you can relax a little bit. Third question, how long does the whole process take? Well, that depends on a lot of things. Generally, Chapter 7s, they're moving through the court system a lot faster. Just to get into it a little bit, Chapter 7 is where you're wiping out all of your unsecured debt. You're wiping out all of your unsecured creditors. And even if you have secured creditors like car payments or mortgage payments, you're technically wiping those out too, unless you sign a reaffirmation agreement. We won't get into reaffs right now, but we will at a later date. But essentially, you're just wiping everything out and you're not paying anybody back in a Chapter 7. So in a Chapter 7, again, how long does the process take? Well, here in the Central District, things are moving a lot faster than they used to. Filings are down recently, so things are getting approved faster, files are moving faster. If there are no issues with your case, meaning you're not getting audited, or perhaps the trustee's not asking for additional documents, your whole case from filing date to your discharge date should be somewhere in the neighborhood of 4 to 6 months. These days, honestly, people are getting their bankruptcies discharged within about 4 months of filing, whether that's downtown, Woodland Hills, Santa Barbara, wherever you may be filing it in the Central District. So you're looking at about 4 to 6 month turnaround time, 6 on the long end, 4 on the short end, and in some cases I've even seen them being approved earlier than that. So it's not an incredibly lengthy process. The benefit, in case you're thinking it takes a long time, is that once the case is filed at time 0, you actually are afforded all the benefits of a bankruptcy, meaning nobody can sue you, garnish your wages or levy your bank accounts anyway. So it's more of a waiting game. Chapter 13 is slightly different. Chapter 13 is a repayment plan, and you're typically being set up on a repayment plan anywhere from 3 years to 5 years. So that's how long that will take. It's much more. It's a much lengthier process because you're paying your creditors back. Question number 4. I have clients that come into my office. We analyze their case, and they ask us, or they tell us, I don't want to include my car in the bankruptcy, or I don't want to include this in the bankruptcy, or I don't want to include my house in the bankruptcy. It doesn't work like that. Just to be straightforward with you, you don't get to cherry pick what goes in a bankruptcy and what doesn't. This is essentially a proceeding where the government's scratching your back by letting you wipe off all of these debts, but you have to reciprocate by including all of your assets in the bankruptcy, including all of your liabilities as well. So you don't get to choose what goes in and out. Now, that doesn't mean you're going to lose everything. Quite the opposite. The reason you include everything in the bankruptcy is to be upfront about what you own so that you don't lose it. Because if you don't include a certain asset, you're basically lying to the court about what you have and what you don't, and it is therefore no longer subject to being exempt. So keep that in mind. So no, you can't cherry pick. You can't say, oh, I don't want to include this asset or I don't want to include that asset in my bankruptcy. You have to include and disclose all of your assets to the court system when you are filing bankruptcy. But don't be fearful. That doesn't mean you're going to lose it now. Quite the opposite. Last question for today. I have clients asking me this all the time. I'm not too sure what the obsession is with Macy's, but I don't want to include my Macy's credit card or my Macy's charge account in my bankruptcy. And this applies to anything. When people say, I don't want to include this credit card, that credit card, or whatever credit card they have an affiliation to or an affinity to, because maybe they've been an Amex member for 20 years and they don't want to include a certain credit card. It doesn't work like that. Similar to the last question, you have to include all of your assets, and you also have to include all of your debts in a bankruptcy filing. Not only do you have to include them, you're signing off under penalty of perjury on your paperwork that you're including all of your assets and debts. And on top of that, when you go to your 341 hearing, the trustee will also ask you once again redundantly, have you included all of your assets and all of your liabilities? Liabilities meaning your credit cards. Now, some people say, well, what if I pay it off really quick? You can try to do that, but there are rules against paying one creditor off over another. It's called preferential treatment, and you're not supposed to pay one creditor off more than $600 within a 3-month period up until the date of filing. So easier bet is just don't pay anybody off. And just as an aside from that, many people who do want to keep their credit cards or a specific credit card, even if they somehow have it paid off by the time they file the bankruptcy and don't include that debt, do bear in mind that most of these credit card companies run a periodic soft inquiry on your credit report, and when they do see you file bankruptcy, they'll probably dump you as one of their clients anyway, so you would have gone through all that process for nothing. No offense to any of the credit card companies, but they are not really humans. They're just a series of computers and databases. So you may think you have this long-standing reputation with them, and they'll probably show some forgiveness to you because you've been with them for a while, but that's not really the case. When the computer sees you file bankruptcy, in many instances, they'll probably cut you as a client. Now, that's not a permanent thing. You may be reissued a card down the road when your credit's restored, and we'll get into the nuances of that in another episode, but just so you know, yes, you have to include all of the people and all of the companies, everybody you owe money to in your bankruptcy, and that is for your benefit as well. So without further ado, those are the questions we've answered for today. We'll come up with another series. I hope this has been informative to you. If there are any details of what I've asked that are not clear, you are welcome to email us at info@syndicatelegal.com. and we'll be happy to answer any of your questions. Okay, thanks a lot, and everybody have a great day. Bye.